Good evening, my dear students. Now we are discussing fourth module of our corporate regulation. It is management of company. Under this, we have discussed some areas of management of company. Let us see what are the areas we are discussed here. I think board and governance, director, women director, number of directorship, etc. We are discussed in our previous classes. Today we would like to discuss independent director. Who is an independent director? I think it's a probable question for your public examination. Let us see. According to section 149, subsection 4, every listed company shall have at least one third of total number of directors as independent director, and the central government may prescribe the minimum number of independent director in case of any class or any classes of public companies. An independent director in relation to a company means a director other than a managing director or a whole-time director or a nominee director. I will repeat the same sentence. An independent director in relation to company means a director other than managing director or a whole-time director or a nominee director. Okay. Who, in the opinion of board, is a person of integrity and possesses relevant expertise and experience. Another condition, who is or was not a promoter of the company or its holding or subsidiary or associate company. Who is not related to promoters or directors in the company, its holding subsidiary or associate company. Who has or had no pecuniary relationship with the company, its holdings, subsidiary or associate company, or their promoters or directors during two immediately preceding financial year or the current financial year. This is called independent director. Okay. Now let us see what are the procedure for the retirement of directors. Before that, let us see number of directorship that we have discussed in our previous classes. Anyway, let us see number of directorship. A person can act as a director, including any alternative directorship in a company, is limited to 20 at the same time. This maximum number of directorship in public company, including the directorship of private companies that are either holding company or a subsidiary company of a public company, is limited to 10. You please remember this number 10 and 20. Any person holding office as a director in companies more than the limit before the commencement of act shall within the period of 1 year from such commencement. There are sub rules. So choose the companies in which he wishes to continue to hold the office of director, or another condition, that is, shall resign his office as a director in other remaining companies, or intimate the choice to each company and the registrar. Okay. If a person accept an appointment as a director in contravention of the above provisions, that contravention means that we have discussed it 10 or 20, and some subclauses are discussed here. In contravention these subclauses or these provisions of this act, any person receives or accept any appointment as a director, he shall be punishable. That is a punishment, that is a legal provisions. He will be punishable with fine which shall not be less than 5,000 rupees, but which may extend to 25,000 rupees for every day after the first day during which the contravention of the companies. Clear? The next one, let us see. Next point, that is sixth point. Retirement of directors. An articles of the company may provide the provisions relating to the retirement of all the directors. If articles of a company do not provide these, not less than 2/3 of total number of directors of a public company shall be liable to be retired by rotation and eligible to be appointed at annual general meeting. If vacancy is not filled up in the adjourned meeting also, then the retiring director shall be deemed to have been reappointed unless the following cases. Let us see following cases. Before that, let us see what is the procedure. Articles of the company may provide the provision related to the retirement of all directors. If the article of the company do not mention or do not provide this case, clear, not less than two-thirds of total number of director of the company shall be liable to be retired by rotation and are eligible to be reappointed at annual general meeting. Clear? Then what are the provisions? What are the cases? If at that meeting or at the provision meeting, previous meeting, a resolution of appointment has been put to the meeting and lost. Another clause, if retiring director expressed his unwillingness to be appointed by way of written notice. Clear? Then another one, if he is not qualified for the appointment, that we are discussed in our disqualification of shares and qualification that we are discussed. Then the last clause, that is, if a resolution, whether special or ordinary, is required for the appointment of his appointment by virtue of any provision of the act. Okay, these are all the conditions. Next one, that is duty of the company. See, what are the duties as a director? The company is required to provide all assistance and facilitate to the company, the secretary in practice. Clear? For auditing the secretarial and related records of the company. The board of directors in their reports before a company in general meeting shall explain in full and qualification and or observation or other remarks made by the company secretary in practice in his report. This is the primary duty of a director. Clear? The company is required to provide all assistance and facilities to the company secretary in practice. That is the main duty of the company. Okay. Then the last point that we are discussed as a part of management of the company is punishment for the contravention. We are discussing many provisions in relation to the directorship and director. So what are the provisions regarding the violation of these provisions? Director of the company shall be punishable with imprisonment for a term which may extend to 6 months or with fine which may extend to 50,000 rupees, and where the contravention is continuing, on which the further fine which may extend to 500 rupees for every day after the first day during which the contravention continue. Clear? What are the contraventions? We have discussed many duties, responsibilities, etc. in our previous classes. When the director is violating these rules, he will be punishable with imprisonment and fine. Okay, these are all the provisions regarding the directorship and different types of directors and the duties, etc. Now let us see what is meant by DIN, Director Identification Number, that we are discussed in our previous classes in general. See in details what is meant by Director Identification Number. Some important point that we are discussed as a part of this DIN. First one, DIN expansion, that is Director Identification Number. What are the procedures for getting this DIN? Application for allotment of DIN. Section 153. Every individual intending to be appointed as a director of the company shall make an application electronically or for allotment of a director identification number to the central government in such form and demand and along with such fees as may be prescribed. Clear? First we have to give application for getting this identification number as per section 153. The next, allotment of DIN, section 154. See, central government shall within 1 month from the receipt of the application may allot director identification number 1 to an applicant in such a manner as may be prescribed. There are many provisions regarding the allotment of the identification number. Based on these provisions and legal formalities, central government may allot director identification number 1 to an applicant in such a manner as may be prescribed. The next, all these provisions are described in section 153 to 158, clear. So next section, that is prohibition to obtain more than one identification number as per section 155. See what are the provisions. No individual who has already been allotted director identification number once shall apply for obtain or process and another directorship director identification number. Okay, that we have discussed. Only one individual is allotted one identification number. No individual who has already been allotted director identification number shall apply. Okay, that is prohibited as per section 155 of the Companies Act 2013. The next, as per section 156, direct to intimate director identification number. Every existing director shall, within 1 month of the receipt of a director identification number from the central government, intimate his director identification number to the company or all company to wherein he is a director. It's very important provision. Once we are getting an identification number, should report the company. Okay. Then no director can continue as a director without intimating the directorship number. Okay. Then next, company to inform director identification number to the registrar within some stipulated period as per section 157 of the Companies Act. See what are the provisions. Please wait for getting slides. As per section 157, every company shall, within 15 days of the receipt of the intimation of director identification, furnish the director identification number of all its directors to the registrar or any other officer or authority or concerned authority as may be prescribed by the central government, with such fees as may be prescribed or with such additional fees as may be prescribed within the specified on section 403, and every such information shall be furnished in such a form and manner as may be prescribed. Okay, there are three procedures. First we have to apply, then we will be allotted, then it will be intimated to the company, and the company should inform to the registrar. Okay, these are the procedure as per section 157 of the Companies Act 2013. Okay, one more section in continuing with this director identification number, let us see, that is 158 of the Companies Act. See what does it mention. Please wait. Director identification number. Then obligation to indicate director identification number as per section 158. Every person or a company, while furnishing any return information or particulars as are required to be furnished under this act, shall mention the director identification number in such return, information or particulars in such return, information or particulars related to the director or certain any references to any director. That is an obligation. Clear. Then the last things that we have discussed, register of director and key managerial personnel and their shareholding as per section 170. See, every company shall keep as it registered at its registered office a register. Clear. Every company shall keep a registrar at his registered office containing, what is it containing? Containing the particulars of its director and key managerial position or personnel, which shall include the details of the securities held by them in the company or its holding or a subsidiary company, holding company or associate company. It's a register. Now as per section 170 of the Companies Act, every company should maintain this kind of register at the registered office. Okay, let us conclude today's class by this. Okay, now thank you to all.